Book 6, Post-Employment, Title 1, Termination of Employment. Article 293, Coverage. The provision of this title shall apply to all establishment or undertakings, whether for profit or not. Persons employed in commercial, industrial, and agricultural enterprise, including religious, medical, or educational institutions operating for profit, shall have the right to self-organization and to form, join, or assist labor organizations for the purpose of collective bargaining. In Article 294, Security of Tenure, in this case of regular employment, the employer shall not terminate the service of the employee except for a just cause or when authorized. Because an employee who is unjustified dismissed from work shall be entitled to restatement without loss of seniority rights and other privilege, and to his full back wages, exclusive of allowance, and to his other benefit or their monetary equivalent computed from the time his compensation was withheld from him up to the time of his actual restatement, as amended by Sec. 34 RA number 6715. Is one of the basic rights of workers. The second one is every employer shall be assured security of tenure. And the last one, the right not to be removed from work except for a just or authorized cause and only after due process. What is tenure? General sense, the term tenure describes the length of the time that a person holds a job, position, or something of value. In the context of academic employment, tenure refers to faculty appointment for an indefinite period of time. When an academic institution gives tenure to an educator, it gives up the right to terminate the person without good cause. Just cause, any wrongdoing committed by an employee. The first one is serious misconduct, and next, willful disobedience of employers' lawful orders connected with work. The third one is gross and habitual neglect of duty. And next, fraud or willful breach of trust. And next, commission of crime or offense against the employer, employees, family members, or representative. And the last one is another analogous case. And next, authorized cause, an economic circumstances not due to the employee's fault. First one, introduction of the labor-saving devices. The second one is redundancy. And the third one is retrenchment to prevent losses. And the last one is closure or cessation of business. And the last one is due process, in cases of just cause involves. The first one is notice to employee of intent to dismiss and grounds for dismissal. Next is opportunity for employee to explain his or her side. Last one is notice of decision to dismiss. Next, expert from Section 3, Article 13 of the 1987 Philippine Constitution says, the state shall afford full protection to labor, local and overseas, organized and unorganized, and promote full employment and quality of employment opportunities for all. It shall granted the rights of all workers to self-organization, collective bargaining, and negotiation, and peaceful concerted activities, including the rights to strike in accordance with law. They shall be entitled to security of tenure, human condition of work, and a living wage.
Article 295, Regular and Casual Employment.
The provisions of written agreement to the contrary, notwithstanding and regardless of the oral agreement of the parties. In this Article 295, it includes regular employment, project employment, seasonal employment, casual employment, and last is fixed period employment. So let's proceed first to the regular employment. Work on a recurring basis performed for remuneration in a trade, business, profession, or other occupation in this state. This is also an employment of a continuing nature, although for no definite period, is a regular employment. It is the consistent employment of a working force by an industry over a given period of time. There are also two kinds of regular employees. First is those who are engaged to perform activities which are usually necessary or desirable in the usual business or trade of the employer. Second is those who have rendered at least 1 year of service whether continuous or broken, with respect to the activity in which they are employed. Next is project employment. When an employee is hired for a specific project or undertaking and the employment duration is specified by the scope of work and or length of the project. Next is seasonal employment. The practice of workers and professionals finding work during specific months of the year and being idle during the other months in which they do not have any concrete job. It is also the one who has been engaged to render work during a season. The employer must be justified in hiring additional help by a seasonal employees. Seasonal employees shall work during the specified season only. A season is a period inside a calendar year. A season requires a start and an end. For example, someone who works at a resort during the summer might experience unemployment once the fall arrives and summer facilities have to close. Next is casual employment, involving an employee who is not entitled to paid annual leave and paid sick leave. Casual employment contract is an employment arrangement between an employer and a casual employee. A casual employee is neither a regular employee, project employee, nor a seasonal employee, as defined under the Labor Code. Casual employees are also referred to as a contractual employees. For example, a mechanic who is hired from time to time to fix the machinery in a manufacturing company is a casual employee. Last is fixed period employment, a contractual relationship between an employee and an employer that lasts for a specified period. These contracts are usually regulated by country's labor law to ensure that employers still fulfill basic labor rights, regardless of a contract's form, particularly unjust dismissal. Seafarers is included in fixed period employment. Seafarers are considered contractual employees. Their employment is governed by the contracts they sign every time they are rehired, and their employment is terminated when the contract expires. Their employment is contractually fixed for a certain period of time.
Article 296 Probationary Employment. Probationary employment shall not exceed 6 months from the date the employee started working unless it covered by an employee who has been engaged on a probationary basis, may be terminated for a just cause, or when he fails to qualify as a regular employee in accordance with reasonable standards made known by the employer to the employee at the time of his engagement. An employee who is allowed to work after a probationary period shall be considered a regular employee. So basically, probationary employment is a trial period where an employer is given time to decide whether the company wants the employee to join the company as a regular employee. Probationary employment should be 6 months or less, unless there's a longer apprentice agreement exceeding 180 days of employment will make the probationary staff a regular employee. A probationary employee may be terminated for just causes, like their faults, or when he fails to qualify as a regular employee in accordance with reasonable standards made known to him from the beginning of his or her employment. If he or she failed the evaluation, employer has the right to terminate his or her employment within the probationary period. Purpose and reason of probationary employment. Before we proceed to purpose and reason, let's define first what is probationary employee. Probationary employee, this is the person who is being observed and evaluated to determine whether or not he or she is qualified for permanent employment. Employer and employee has both purpose and reason with probationary employment. Let's proceed first to employer. Probationary employment allows the employer to assess suitability of the role after having first-hand experience, and he can observe if the employee is fit and efficient to his or her job.
It gives the employee or probationer to prove herself or himself with the employer that he can meet the standards set by employer to become a regular employee, and also it gives the probationer the opportunity to see whether they like their new job and surroundings. Standard of probationary employment. First, employer must advise or orient the probationer employee that he or she is under observation or under probationary basis, wherein he or she has a chance to become a regular employee. But if the probationary employee disobey or violated the set rules standard of employer, he or she can be terminated as a probationary employee. Second, if the employer did not give any agreement or standard, you are considered as a regular employee. If the employer did not give any standard or agreement, you are considered as regular employee. But it has exemption, like if you have self-descriptive job, you are not considered as regular employee. For example, maid, cook, driver, messenger, and online seller. The last one is, if no documentary evidence shows that the employee is probationary, he or she is a regular employee. So this picture is the example of probationary agreement. This has the content of terms and conditions given by the employer. It outlines the duties and responsibilities of the probationary employee. It outlines the rights, compensation, and benefits of the probationary employee. It also outlines the standards or criteria under which a probationary employee will be evaluated to see if he or she qualifies as a regular employee. Even they are temporary employee, they still have the security of tenure. Temporary employee cannot be terminated except for causes as provided by law. For example, first, serious misconduct. Serious misconduct is conduct that is willful or deliberate and that is inconsistent with the continuation of the employment contract. Serious misconduct includes theft, fraud, assault, intoxication at work, and the refusal to carry out lawful and reasonable instructions consistent with the employment contract. Second, willful disobedience or insubordination. Willful disobedience or insubordination. This is a rebellious, stubborn, and determined intention to do what one wants, regardless of consequences or effects. Willful disobedience is the employee's deliberate choice to disobey even after he or she has been reminded and given a chance to correct his behavior. The last one is fraud or willful breach of trust. Fraud or willful breach of trust. It means there must be an act, omission, or concealment on the part of the employee, which involves a breach of legal duty, trust, or confidence justly reposted, which justifies the loss of trust and confidence of the employer to the employee. When those cases happened, or if the termination is for a cause, the termination can be done anytime during the probation. The employer does not have to wait till the probation period is over. But there is three limitations in terminating employee. First, it should still accord with the requirements of contract. Second, the satisfaction of employer must be real and in good faith, not feigned to circumvent the law and contract. And the last one is, there must be no unlawful discrimination against the employee. Article 296 states that an illegally dismissed employee is entitled with two reliefs, which is back wages and reinstatement. Reinstatement is under Article 294, which is providing for reinstatement. Reinstatement means action of giving someone back a position they have lost. It clearly means that even the employee is dismissed or terminated, just or unjustly, he or she still receive a separation pay, and even her probation is 6 months, it is already counted as 1 year. he or she will receive a 1 month separation pay, and if the dismissal is illegal, the employee also entitled to have back wages, but the back wages will not cover the whole time. The cover of it is only the period from the date he or she was dismissed up to the last day of the agreed probation period. Duration of probationary employment. First, the duration of probationary period of employment is limited to 6 months, but it can also exceed 6 months if that is the agreement of both parties because the job is complex enough that the employer needs a longer period to assess the qualification and fitness of probationer. Second, they can also have a voluntary agreement exceeding the original probationary period. It is based on employee's request to give the employee a second chance to pass the probation standards. The last one is double or multiple probation is not allowed. And it says that the last day of probationary period is 6 months, which means 180 days.
Article 297 Termination by Employer. First, serious misconduct or willful disobedience by the employee of the lawful orders of his employer or representative in connection with his work. An employee is subject to termination once he or she committed a serious misconduct and carry out insubordination to the law implemented by the employer. Example of serious misconduct is sexual harassment. It is acceptable enough to be a cause of dismissal, but it is more severe if it is done by the people with dominant power. The willful disobedience by an employee may constitute a just cause for terminating his employment. The orders, regulations, or instructions of employer is based on 3 elements. First, reasonable and lawful. Second, sufficiently made known to the employee. And third, in connection with duties which employee has been engaged to discharge. The employee's disobedience, in order to justify his dismissal under this provision, must be vindicated by the lawful and valid reason. Is ignorance an excuse? If the employee claims ignorance of the company policy, the employer must disprove it, unless the employee will not get punished. The Civil Code declares that ignorance of the law excuses no one from compliance therewith. This applies on compliance with laws of the Republic, but the policy to be issued to a private enterprise is not on the scope of this declaration. Thus, the employer has the responsibility to inform his or her employee about the policy, otherwise, in the end, they are the one to be blamed. Second, gross and habitual neglect by the employee of his duties. An employer can terminate an employee if the worker continuously fails to fulfill his or her duties towards its work. Neglect of duties not just only be gross but having it as a habit. Example is abandonment of job. The employee failed to report for work or absence without valid reason or further notice. A clear intention to sever the employer-to-employee relationship. The employer should prove that the employee show unjustified refusal of the employee to continue his employment. Third, fraud or willful breach by the employee of the trust reposed in him by his employer or duly authorized representative. The employer can terminate his employee if the employee committed a fraud against his employer in connection with the employee's work. Loss of confidence applies only to employee that holds a concerned position of trust and confidence by his employer. Example is cashiers. They are entrusted to take care of the money, and if the employer lost the trust and confidence on a said employee, it may justify the termination of their employment. Fourth, commission of a crime or offense by the employee against a person of his employer or any immediate member of his family of his duly authorized representative. The termination of employee may be caused by performing any illegal offense to his employer or to any immediate or relatives of employer's family. And lastly, other causes analogous of the foregoing. Analogous cases can be cause of termination. Example is stealing, violation of company rules and regulations, and attitude problem of employee that affects the working environment. Upon knowing all of the causes that may lead to employees' termination, let's talk about the process they need to undergo in order to have a fair decision. Due process. Every employee is entitled to due process. This is a fundamental right and partaking the nature of human rights. The Philippine law conceives due process in two senses. First, substantive due process. Employee's dismissal is justified by lawful and valid reason. Second, procedural due process requires ample opportunity for the worker to explain his side before going down to the final decision. The two groups of causes are just and authorized causes. Just causes refers to a fault, misdeeds of employee. This is commonly the causes being processed in substantive due process. An employee being dismissed due to just causes will not get separation pay unless based on compassion, financial assistance may be given to the deserving dismissed employee. Just causes due process consists in notifying and hearing of employee. In just causes, the effectivity date of dismissal is determined by the employer. Authorized causes are causes refers to business or economic reasons. Examples are introduction of labor-saving devices, retrenchment to prevent losses, and closure of business. In authorized causes, employer is required to give a separation pay to the employee except case of business closure due to serious business losses that has been proved. The due process to authorized causes, no hearing is needed but notices to the employee and to the Department of Labor and Employment should give in 30 days before the employee separation. And lastly, separation due takes effect at least 30 days after the employee received the notice. Dismissal procedure. Dolly Department Order Number 147-15, approved on September 7, 2015, note that termination disputes are subject to compulsory conciliation mediation. Conciliation mediation. It is a mode of argument settlement that brings two disputing parties to negotiate and settle their differences. It is a process of rational and orderly discussion of differences between the parties. The implementing rules provide that no worker shall be dismissed except for the just or authorized causes provided by the law after the due process. The two sides of these legal provisions are, first, the legality of the act of dismissal under the grounds provided under Article 297 of the Labor Code, and second, legality and manner of dismissal. Due process in just cases. Under Article 297, the law requires the employer to give the worker two written notices before terminating his employment. A notice charging the employee on the specific causes or grounds for termination provided under Article 297 of the Labor Code as amended and company policies if any. It should include detailed narration of the facts and circumstances that will serve as basis for the charge against the employee. A directive that the employee is given opportunity to submit a written explanation within a reasonable period. Reasonable period, at least 5 calendar days from receipt of the notice to give the employee an opportunity to study the accusation, consult, or be represented by a lawyer or union officer. And after serving the first notice, the employer should afford the employee ample opportunity to be heard, further means the right of the employee to detail, verbally or in writing, his answer to the charges and submit evidence supporting his defense in a hearing or other fair and reasonable way. A face-to-face investigation is not always required, but it becomes compulsory if requested by the employee in writing, if substantial evidentiary dispute exists, if a company policy or practice requires it, and if similar circumstances necessitate a formal hearing. If the employee admitted his infractions, no formal investigation needed, but all is needed is to inform the employee of the decision of the management. Due process in authorized causes. If the cause of separation is based on the authorized causes, under Article 298 to 299, the law required to give both the worker and the dole written notices 30 days ahead of the projected separation. And if the number of employees is affected, the notice should be to each individual, not to the group. And if it is caused by disease, due process is observed, medical certificate is substantive requirement, and its absence makes the termination unauthorized and illegal. Separation pay. An employee terminated due to installation of labor-saving devices or redundancy shall be paid equivalent to at least 1 month pay or at least 1 month pay for every year service. Whichever is higher, a fraction of 6 months service is considered as 1 whole year. Terminated due to retrenchment, employees shall be paid equivalent to 1 month pay or at least 1.5 month pay for a year service. Whichever is higher, a fraction of 6 months service is considered as 1 whole year. Terminated due to closure or cessation of business operation, not due to serious business losses, shall pay the employee's reparation equivalent to 1 month or at least 1.5 month pay for every year service. Whichever is higher fraction of 6 months service is considered as 1 whole year. But when closure is due to serious business losses or financial reverses, no separation pay is required. And lastly, terminated due to disease shall be paid by the employer a separation pay equivalent to at least 1 month pay or 1.5 month salary for every year of service. Whichever is higher, a fraction of 6 months service is considered as 1 whole year.